Hello, I'm Jim Turk, the director of the Center for Free Expression, and I'd like to welcome you to the next in our series of conversations and panels for 2024-25. Before I begin, however, I want to acknowledge that the land on which I am speaking to you this evening is the traditional territory of many nations, the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I'd also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties with multiple Mississauga and Chippewa bands. I'd also like to thank our co-sponsor for tonight's discussion. That's the Edmonton Public Library, the Toronto Public Library, and PEN Canada. Thank you to all three of you. In recent years, we've seen growing demands for censorship and increasing numbers of acts of censorship. There have been the calls for books to be banned from public libraries and school libraries, speakers being canceled, film screenings disallowed, the most recent being the unprecedented decision of the board, the politically appointed board of TV Ontario, to withdraw its support for the widely respected documentary Russians at War, and to refuse to allow it to be broadcast on TVO after they were responsible largely for financing it. Or how several Canadian universities like York, Alberta, Laval, and Calgary called the police almost immediately after encampments were set up on their campuses, police that often brutally ended the anti-war protest encampments. Our featured guest today is Richard Moon. Richard is a distinguished university professor and professor of law at the University of Windsor, and one of the most respected Canadian thinkers on freedom of expression, who has just written a brand new book with a provocative title, The Life and Death of Freedom of Expression. In it, he questions whether the assumptions behind our commitment to freedom of expression still hold in an era in which social media has helped create a situation which, as Professor Moon writes, it seems to be the case that, and I'm quoting, opinions that are adopted without judgment often become entrenched as a matter of group identity and loyalty, and vigorously defended, not through argument, but instead through group identity and counterattack, therefore putting into crisis the public discourse on which democracy depends. Public discourse, which, as he writes, requires some level of agreement about facts or authorities, and a willingness to engage with others, including opponents, and to regard their views as serious and worth discussing. Welcome, Richard.
Thanks so much, Jim. I'm happy to be here.
I'm glad you are. Tonight, we're going to explore these ideas, ask, are they right, and discuss what can be done. Nothing less than the future of our democratic society may be at stake. In conversation with Richard Moon will be David Schneiderman, himself an important scholar of expressive freedom and professor of law and political science at the University of Toronto. Welcome, David.
Hi, Jim.
So for the audience, for the next 45 minutes or 50 minutes or so, David and Richard are going to be in a conversation about this range of issues related to freedom of expression. And we'd invite the audience to, if you have questions that come up as you're listening to them, if you look at the bottom of your screen, you'll see a little box with a question mark in it, and underneath it says Q&A. So at any time as you're listening to their conversation, just click on that box and enter any question you'd like them to address. We're going to turn after their conversation for half an hour or a little longer to questions from the audience. So if there's questions you'd like one or both to answer, write them down as you think of them during their conversation. You don't have to wait till David asks. Ange Holmes, the coordinator of the center, who's monitoring the questions, will be putting forward the questions as the discussants would like. So take advantage of this opportunity to have your questions addressed by two really interesting and thoughtful people on these issues. So over to you, and I'll see you at the end of the program.
Thank you, Jim. Good evening, Dick Moon.
Good evening, David Schneiderman.
It's really a pleasure to speak to you this evening about your new book. the life and death of freedom of expression. So why death? Why is freedom of expression dead?
Okay. So I guess the first thing to say, and this is in the form of a confession, is this book began as a second edition of a book I wrote now 24 years ago. But of course, as I worked on this particular project, my idea being a second edition came to realize, with some encouragement from the publisher, that the landscape had changed so dramatically that it really was becoming a different book. So much so that it was, couldn't really properly be described as a second edition. Now, the earlier book had as I've described it, eye-catching title, The Constitutional Protection of Freedom of Expression. That was not a book. That was not a title that people were, immediately drawn to and, pulling off the shelves. So I thought maybe something that was a little catchier might help a bit or generate a little more interest. So that's my confession to begin with. But with that said, the idea of the life was to say, look, we have free speech gets talked about, we have cases, we have decisions, we have debates about free speech in the community. But when I talk about the death of free speech, probably that's slightly misleading. In many ways, it's really about the death of public discourse. That public discourse is on a serious decline, that we are increasingly limited, it seems, or unable to converse with one another in a serious and, even slightly civil way on a variety of issues. We're often locked in our own networks, our own bubbles, and not exposed to other views. And so in many ways, I'm really talking about the decline or the death of public discourse. With that said, I also believe that state censorship, which has always been the focus, at least of our constitutional right to free speech, is maybe less a concern or less a threat. I mean, it's still something we need to be alert to and concerned about, but maybe less a threat or less a concern than simply the flood of disinformation out there, where people either don't know what to believe or they will simply believe what they're already predisposed to believe in some way. So I guess that's what I'm really trying to say. First, that public discourse seems to be on the decline, our ability to engage with one another, and maybe our focus on state censorship needs to shift a little bit.
So is it the case that when you wrote your first book, the first edition or first version of this book, that we were in some kind of golden age?
No, far from it.
Expression was alive, and now we've
No,
arrived
far
at
from
its
it.
death's door.
Yeah, no, certainly far from it. I would say, and in the first book, and I repeat some of this in this book, there were certainly important challenges to public conversation. So one of them was privately owned media, which was increasingly concentrated everywhere, but in Canada in particular. And of course, there were real, genuine concerns that these privately owned media corporations would profile some perspectives and filter out others, particularly more radical, progressive perspectives. So that was itself a real concern. And in many ways, the arrival of the internet was seen, at least initially, as a kind of, an antidote to that suddenly there was this possibility of platforms that would allow individuals to express whatever views they might have that wouldn't necessarily be filtered out by gatekeepers. We could talk a bit more of that in a minute. And of course, the other concern was how much of our public conversation, or at least public communication, took the form of commercial advertising, in particular lifestyle advertising, which is not really meant to appeal to individual reflection or judgment, but is really meant to impact individuals at a much more visceral level. So there were real concerns, no question about it. And as I say, in many ways, it was initially thought that the internet might address some of those. And in one way, it has allowed individuals to express views, to connect with others who may be like-minded, and avoid the filtering effect of the traditional media. But certainly, it has in many ways made worse the ways in which we engage with one another and the effectiveness of advertising. And yeah, I don't know if this is too early to get into this, but of course, one of the things that social media platforms has made possible is the micro-targeting of ads. So ads can be based on the personal data that these platforms gather. These ads can be very specifically tailored to individuals or small groups of individuals, and they can be directed to those individuals in ways that others are not aware. You might think the ad you're getting is one that is being received by a large number of people, but very often it's not. And that creates challenges around the ability to contradict those ads, dispute them, and so forth, if we are simply unaware of them. So, I don't want to get too much into the reads on this, but just to say that, of course, there was no golden age. At the same time, I think there are many ways in which things have gotten much worse.
Right. So we're in a pretty dark place. And the book certainly makes that point, and maybe we'll come to that as we move through the conversation. But I wanted to give you an opportunity to kind of frame the outlook that you take on freedom of expression and why it's important in a democratic society. What's the rationale, in your view, for protecting communicative freedom?
Sure. Sure. I mean, traditionally, as you know, there are sort of three accounts that are often put forward to account for to explain why free speech matters. So one of them is it's essential to the realization of truth or the growth of knowledge within the community. Another is it's necessary to the operation of a democratic form of government. And another is tied more to the individual. The individual realizes him or herself through communicating, engaging with others, or it's important, if we're going to respect the autonomy of the individual, to respect his or her ability or freedom to express their views and put them out in some way. And I don't take issue with any of those accounts, but I do think at the foundation of each one of those, and something that I feel is often missing when these accounts are elaborated upon, when they're developed, is a recognition of the social character of agency and identity. So when I first started thinking about freedom of expression so very long ago, I began with a very simple observation that the right to free speech doesn't simply protect the individual's liberty. It protects the individual's liberty, the individual's freedom to engage in a particular activity that is deeply social in character, that involves reliance on particular languages, socially created languages, draws on community resources, whether that's the internet or public parks, and that involves engaging with others. And so beginning with this recognition of the very social character of the right, I really began to think more about why expression mattered. And I would put it this way, that our identity, our agency, or more specifically, our ideas and feelings take shape when we give them, when we express them, when we give them linguistic form and put them before ourselves and before others, and are able to reflect upon them and hear what others' reaction or see what the reaction of others is to these particular views. And of course, the audience, the listener, him or herself, also exposed to these different views, reflects upon them, reacts to them, incorporates them in some way within their existing frame or understanding. And so I think once we recognize that our ideas and feelings take shape when they are given linguistic form, when they are put out in front of us, that's actually is what makes expression so vital and so critical. So we can talk about democracy, truth, self-realization, but each one of them is about how one realizes in a particular context one's agencies, one's identity, how one participates with others in the common world. I don't know whether that's clear enough or not, but
Well, I have a sense of what you're saying. The social element to communication is what justifies or protecting constitutionally freedom of expression. You write that expressive activity is intended to elicit a response. So you talked about the audience, listener. I'm wondering about the rationale from self-realization. You mentioned truth and
right.
democracy. And what about expressive activity that's not intended to elicit a response? What if it's intended to elicit no? What if it's merely expression for self-satisfaction? What about visual expression that doesn't elicit any kind of might not be any kind of reaction? You're in an art gallery, move on to the next painting. How do you fit those kinds of scenarios into your rationale for protecting freedom of expression?
Yeah, I mean, I would describe it as always, or at least in its central forms, as a relationship. So a relationship of some kind between speaker and audience, and of course it can go back and forth depending on the particular dynamic. Um, and I think that when we think of expression, or at least communication, if maybe that's the better term to use here, when an individual expresses him or herself, communicates, ordinarily at least, they want and are signaling to the audience that they want the audience to recognize they're conveying meaning or message to them, and hope that the audience will be able to grasp, at least at some level, what they're seeking to communicate. I think that's the central dynamic. But if you're talking about, I mean, I would say that's what's going on with an art gallery. The aesthetic experience is different than, I don't know, a philosophical discourse or something like that. But the artist is seeking to elicit some kind of response or reaction from the audience, is asking the audience to reflect upon, contemplate this work of art, whatever they may take away from it. I often use the example of, I forget what gallery it's in, but the urinal that has a frame around it. And now, obviously, a urinal is ordinarily a functional item that we don't think a lot about, and we certainly don't understand it as conveying anything to us. But as soon as it's placed in a gallery, a frame is put upon it, around it, then the creator of this is asking us to look at it differently, to look at it in some aesthetic way, or to reflect upon it in some fashion. So to call it art is in itself to signal your intention to convey or communicate to an audience, and your desire that the audience take away something from it. Now, of course, there are instances where an individual may write something down only for themselves, or draw a picture only for themselves. But even then, they are still using conventional, symbolic, linguistic forms in order to give form to whatever their feelings or ideas are. The diary writer, for example. The diary writer writes something down, and we all know that in the very process of writing something down, we gain a certain clarity in our thinking. Our ideas take a kind of shape or form, and we can see them differently. So even then, we're putting it out in front of ourselves, and it gives us the opportunity to think about or reflect our ideas, our feelings, and we may be writing to a future self, whatever it might be, that I'm going to read this one day. Who knows? Maybe it'll even get published. Your diaries, perhaps, David.
Right. So in those circumstances, you're writing for yourself. You're the audience. You're not intended to elicit a response from anyone else other than yourself. In fact,
and I think
there might be no intention to communicate that to anyone else. Of course, in those circumstances, it's unlikely that that kind of speech will be the subject of any kind of legal regulation, but it could be.
But it could be. No, I agree. And here's the strong connection, obviously, between freedom of thought and freedom of expression. So here we are. We're still, when we're talking about freedom of thought, we're still talking about an individual giving form to their ideas and externalizing them in some way through traditional, or at least establish social symbolic forms of communication, even if they're not sharing it with other people.
So it's not technically expression. More appropriately, freedom
Yeah.
of
Well, it might be. You can just see
conscience.
the strong relationship between the two of them, of course.
Yeah. Um, it's thinking about the art gallery and abstract expressionism, and not the urinal, the Dadaist urinal, but abstract expressionism is meant to elicit in the viewer some kind of rational response. And I think all of your discussion is premised on the idea that human beings are going to be at least presumptively, rationally consuming, listening to that information. Is that the operating assumption in
No,
freedom of?
I don't think so. I mean, I think that obviously that's the core of what we think about when we think of free speech, because most often we think about political speech, for example, as that which is both central and important and most vulnerable, perhaps, to censorship, state censorship historically. But I certainly do, and in the book, certainly include the aesthetic experience, and would say once again that the artist wants the audience to view his or her work as something to be reflected and contemplated upon. I'm certainly no expert on thinking about the aesthetic experience of viewing art and so forth. So how I can probe through that, I'm probably not ill-equipped to do so. And my focus just is on the idea that as long as you are signaling to the audience that you want them to reflect upon what you are seeking to convey, then that counts as expression.
This is meant to be a segue to talk about the Supreme Court of Canada's jurisprudence.
Okay.
Where you write that the Supreme Court of Canada, in its Section 2B, the Guarantee of Freedom of Expression jurisprudence, presumes, right, that listeners are rational, that they
Right.
will behave, right, appropriately in response to the messages that they're receiving. And as a consequence, much speech is caught under the umbrella of Section 2B, right? Even the most deeply offensive speech is constitutionally protected. Hate speech, for instance. And so you make this observation. I found it helpful, actually, in thinking through the Supreme Court of Canada's record on freedom of expression, that there's this very generous approach to expressive activity in Section 2B, but those fundamental freedoms are reasonably limited, and the court then moves its analysis to the reasonable limits stage under what we call Section 1. And there, the presumption of rationality, you say, disappears, just falls out of the bottom of the court's analysis. And instead, the court shifts its attention to harms, to messages that will cause individuals to misbehave. So there's no longer this generous assumption about rationality on the part of the listener. Rather, there's much more concern about harms that will issue out of particular messages. So a kind of loss of rationality. Can you explain how this works?
Sure. Well, I can try. Okay, so first, I mean, the more general argument I make is that to understand both the value and the harm of expression, or at least recognizing that agency, identity, that ideas and feelings take shape when expressed, when given linguistic form and put before us in some way, is crucial to understanding the value, but also the harm of expression. The reality is that a language is not simply transparent. That we are not fully rational beings, that any kind of expressive act can affect us on multiple levels, both very clear and conscious, but also at a visceral level too. And so I think that's really critical to understanding both why free speech is valuable, but also its potential for harm. harassment, manipulation, all the ways in which we think speech can be harmful. And you're right, the Supreme Court of Canada has defined the scope of Section 2B, the freedom of expression right, very broadly. Any act that is intended to convey a message or meaning to an audience counts as an act of expression, says the court. And they illustrate how broad this is by giving the example of parking against the rules. Ordinarily, how you park is not an act of expression, but if you do it as a form of protest, it becomes an act of expression. So I think that because it is so difficult to draw a nice, bright boundary around what counts as an act of expression, given the multiple ways in which any kind of communication can affect an individual, as I say, both rational and visceral levels, the court just takes the easy way out and defines expression very, very broadly. And so, as you say, all the work really happens under Section 1, the limitations provision of the Charter, where the court considers, is it reasonable and demonstrably justified as a limit on this particular important right? And on the question of kind of rational and irrational, yeah, the easy route is to, at the first stage, is to say, oh yeah, individuals, they make judgments, will define the expression very broadly. But then when they get to Section 1 and are considering whether or not it's appropriate to put in place a restriction on hate speech or restriction on pornography or on tobacco advertising, whatever it might be, they come to a recognition that, well, this doesn't necessarily operate in a kind of fully careful, rational way. It can affect individuals at very different levels. And instead of confronting that very clearly and very directly, the court tends to just shift to a different kind of view of the individual. They talk about speech as causing harm, or speech as having the potential to cause harm or create the risk of harm. And they seem at this stage to regard the individual as just, I don't know, an entity that's subject to the push and pull of external influences. And I think that's just a way of avoiding the very difficult, complex question of how speech may affect individuals in a particular situation. Now, if you'll let me, and I know we don't have a huge amount of time, I kind of illustrate this with a very early freedom of expression case, the dolphin delivery case, a case that was concerned with the regulation of secondary picketing in a labor dispute. The courts, the tribunal, the labor board had determined that a particular form of picketing, instance of picketing at a particular workplace was secondary picketing, meaning picketing not at the primary workplace that was the subject of the strike, but at maybe a remotely related entity doing business with the employer that was on strike. In the course of the judgment, the court says, well, picketing is expression, it's communicating a message, it's valuable, it's important, and all of that. And so then they move on to Section 1, the limitations provision, and then they say, well, it causes harm. It's going to cause harm to the business interests of dolphin delivery, and that's an adequate reason to restrict it. But what do we mean by cause harm here exactly? Well, the reality is, of course, that when individuals come across a picket line, some of them may simply refuse to cross because they're uncomfortable with confrontation. Some of them may say, look, I'm a unionized worker. I'm not going to cross somebody else's picket line. They may feel intimidated, whatever it might be. But instead of addressing all the ways in which a particular form of speech in a particular context may place certain constraints on the individual's independent judgment about how they want to react to that speech, the court just shifts to a behavioral thing. It just talks as if the response to picket line is automatic. The picket line is a barrier in the physical sense. And I think that's just the way the court avoids confronting the much more complex issue of speech always takes place in a particular context. It takes a particular form that may, in fact, limit the individual's ability to make an independent judgment. And the question always is, are the constraints or limitations here so great that we think the speech no longer deserves protection, or are they not? But the court simply avoids that by simply talking about it being a barrier or adopting a very behavioral, causal approach or the effect of speech.
Right. So the court seems to be wanting to hide under the cover of the Section 1 limitations analysis.
Absolutely.
And in doing so, engages in protecting, for instance, economic interests in the case of dolphin delivery.
Absolutely, yeah.
Or moralizing about LGBTQ speech in the Little Sisters case. The court sort of comes out of the closet, you might say, in condemning certain forms of speech just because it's, offensive. And so Section 1, this whole Section 1 analysis seems to me to be a real problem. The way the court structures that analysis, though, gives it an allure of objectivity. And I think the task probably that constitutional law folks have is to try and penetrate through that mystique of science and objectivity. But you mentioned commercial speech. I want to ask you just this question about commercial speech.
I do want to return to something here, but yeah.
Yeah, we can do that right after this.
Okay.
The point about commercial speech, which receives a semblance of protection, right? Unlike hate speech, pornography, child pornography.
Right.
Is there then a presumption in the Section 1 stage of an analysis, the reasonable limits analysis, is there a presumption that consumers are rational? So commercial speech is valued by the court. It doesn't receive the same kind of value as political speech, but nevertheless, the court values commercial speech in our consumer society. Listeners have an interest, right, in receiving as much information about consumer products as possible.
Yeah, I mean, that's right. I mean, in the earliest decisions in which the court considered whether or not advertising or commercial speech should be protected under Section 2B, the court said, well, it conveys a message and it has some value potentially to consumers. In fact, borrowing some language from the US Supreme Court, they even suggest to many people, it may be far more valuable than political speech to receive information about products, services, and so forth, which is kind of a depressing idea, but perhaps something true anyway. At the same time, as you know, the court said, well, it's protected speech, but it may have less value than other forms of protected speech, like political speech, because it is profit motivated. Now, different judges seem to have a different take on this, so it's hard to generalize. But certainly for now retired Chief Justice McLaughlin, there was an idea that, well, it's profit motivated, so maybe there's not a lot of value we can attach to the speaker's interest, the company's interest in generating this advertising, but consumers may find useful information here. Like one of the early cases, about dentist advertising. And, maybe there were some things that would be not helpful for a consumer that a dentist might advertise and promote, but there might be other things that are valuable. And so there shouldn't be a general ban on dentists advertising their services. I think that as the cases unfold, you see, however, the court sometimes using the model of the classified ad. And when we're thinking about ads as informational and useful to a consumer, then the classified ad, which is just full of, information about the thing that's being sold, the car, the year, the price, the condition, whatever it might be. On the other hand, the courts do seem to respond differently to what we might describe as lifestyle ads that are not meant to convey an explicit message, but are meant to associate the product with a particular sort of set of values or images or something. And a lifestyle ad, of course, only works if you don't reflect upon it. And they work because there is so many of them that we don't actually have the time to stop and think about them. If I were to, and this is a very old case now, if I were to look at the Marlboro Man ad and reflect upon it, I would think, what the heck? This is ridiculous. But the fact that, the clouds in the sky look like wisps of smoke, you have this rugged, virile cowboy who is smoking this, and all the colors in the background are similar to tobacco products. If you reflect upon it, it doesn't work. You recognize the absurdity. It's just that it passes you by quickly, and you just make this association between the product and these values, but not at a particular conscious level. I think that the lesser value that the court appears to attach to commercial advertising rests upon, or is a proxy for, both a recognition that so much advertising takes a form that is not intended to appeal at any conscious level to the individual, and it overwhelms our public discourse. Advertising, commercial ads are what we see all the time, and they're only effective because they are so commonplace, because they wash over us so completely. So I think it's a proxy for both the volume and the form of this particular kind of communication. Now, am I allowed to go back to say something that I think is kind of critical to sort of understand the overall project? And that is really about speech and its impact on the audience. So ordinarily, we don't think of expression as causing audience behavior or audience action. We don't hold the speaker ordinarily accountable for the reaction of the audience. That's critical to our understanding of the protection of free speech. So members of the audience may really not like what I'm saying and may react in some nasty way towards me, or they may agree with me and they may engage in some kind of harmful behavior. At least ordinarily, or as our starting point, we say, no, the speaker is not responsible. The audience is an independent agent who makes his or her own judgment and is not accountable. Now, of course, this idea of not treating speech as a cause ordinarily rests upon a couple of assumptions. One of them is that individuals are substantially rational, reasonable beings who are capable of making independent judgments. And the other is that individuals have before them, are exposed to a wide range of different views that enable them to consider and reflect upon competing perspectives. Now, when either or both of those assumptions are not present, then we may think differently about speech. And traditional free speech doctrine has always recognized exceptions to the protection when these assumptions are absent. Classically, Holmes' example of the false yellow fire in the crowded theater. Expression in one level, but it occurs in a circumstance or a situation where the audience, those who hear this particular message, are not in a position to make an independent judgment about what's being said. They're not going to stop and reflect upon, gee, I wonder whether there's really a fire. Does anybody else have a view on this question? So in that kind of circumstance, when the conditions for making any kind of independent judgment are so compressed or are absent, then we say, okay, we're going to treat speech as a cause here, as the speaker as responsible for any misleading, for the misleading consequences that may follow, or for the impact of the speech itself on others. And individuals may be, hurt, killed in the stampede of individuals fleeing a particular theater in that circumstance. I gather Mill actually was drawing on real situations that had occurred, in fact, in the States, where somebody had mischievously yelled out fire and people had been killed as they stampeded out of the theater. So, and I guess my larger question, and we can get to this in a minute, is what happens when these conditions are eroded systemically? How do we hold on to free speech when individuals are locked in their particular bubbles and are not exposed to a wide range of views, when they seem vulnerable to conspiracy theories and so forth, and persuaded that they can't trust traditional authorities or traditional sources? When these assumptions are eroded systemically, free speech is really at risk, is really under threat.
Well, let's just go to this point then. What can legal regulation do about this?
Well, that's my real concern. Certainly, traditional legal responses are probably not up to the task of dealing with some of the problems out there online. I think that the internet, and in particular social media platforms, and that's really where most of our public conversation is happening now. I think it has both exacerbated many of the kind of problems, injuries, or harms that speech can generate, but it's also made traditional legal responses to the problem far more difficult or inapt in many respects. So I think about disinformation, for example, and say, well, it was obviously a concern when people would lie, offer falsehoods of different kinds. But the law didn't treat it as a general problem. It focused on particular situations where an individual might be injured or harmed. So defamation or false advertising, situations, limited in character, we might seek to regulate false claims made by somebody, particularly lies. But the problem is so much broader now, and it's hard to know how to address it. Same with harassment. I mean, harassment in the past was something that ordinarily would occur in a particular physical context, in a kind of face-to-face way, most often. And so we focused on harassment, within the workplace, and maybe increasingly out on the streets where an individual might be exposed to, repeated harassing communications or messages. But now online, the scope of it is so much greater. So, and hate speech, of course, has become a gigantic problem. It spreads so widely and so freely online. So how do we address it? Because just talking about hate speech, the traditional legal responses are just too slow, too cumbersome to address the rapid and wide spread of hateful views. And so I think the only answer is the kind of approach that the federal government is considering and seeking to develop at the moment, and that is by placing a duty to act responsibly on social media platforms, by designing their algorithms, their systems in a way to prevent hateful messages from either being posted or from circulating. And this needs, importantly, to be under the auspices of some kind of government agency, which they will consult with. They'll try and tailor these particular algorithms and so forth. And it won't be perfect. I mean, the reality is there is so much stuff out there that the response to it will always involve automation of different kinds to try to identify through algorithms different messages that may be viewed as hateful. So there's always going to be a risk that stuff that shouldn't be taken down will be, and stuff that should be taken down won't be. And it's about trying to develop the systems to minimize both the negative and the false positives, the false negatives, and so forth in a situation like that. It's far from perfect, but I think in this climate, it's hard to see what the alternative is.
And so we run into the same definitional problems as we do under the criminal code. For instance, when you ask media companies to regulate hate speech, those definitional problems remain.
Absolutely. There's always going to be some debate. First of all, what should be prohibited exactly? And secondly, yes, if you have a prohibition on hate speech, people can reasonably disagree what counts as hate speech, and in particular, as the courts have sought to define it, what counts as degrading, dehumanizing speech that vilifies the members of a particular group. I would only frame it as it needs to be extreme, and so extreme that if you were to take the message seriously, if you were to believe it, you would have to think that radical action against the members of that particular group was appropriate and was justified.
So that's incitement. That's incitement to action, and words that actually incite people
Well,
to
but not in an immediate way.
You're asking for an explicit message being sent to listeners.
Oh, there needs to be a message of some kind, but no, I mean, there can be all kinds of things that associate individuals, that suggest that members of a particular community are a danger to our children, or members of a particular community are inherently violent in character. Doesn't mean I'm going to do anything in reaction to it. But if I took the message seriously, I would imagine that some kind of response of excluding these people from society or even suppressing them was justified. That's how I
So,
would. That's how
yeah.
I would view it or understand it. It doesn't mean an immediate. It's not incitement in the sense of we usually use the term, at least in the criminal law context, where an immediate act of violence is likely to follow.
You've written a whole book about this, but this group is a danger to children, is mantra we hear from religious communities, right, in regard to
Right.
LGBTQ folks. And so, how is that to be managed?
Well, yeah, I know that's a real challenge. But if people are expressing this in a public way, then I think it does count as hate speech. And I think it's troubling because, as I say, it will support and justify some kind of exclusion, radical action against the members of the targeted group.
Mhm.
But this is a debate about, hate speech, how hate speech laws work and whether we ought to have them. And of course, there's some people who believe we ought not to. In the States, the courts, have generally speaking struck down such laws. We haven't, but they certainly present challenges.
Yeah, they do. I wanted to ask this last question and
Yeah.
connected to this point about religious speech, which you describe in the book as providing a cover, right, for misinformation, for hate speech and other things. So, in other words, messages that are spread in more seemingly benign ways. And that seems to be a major concern of yours, that it's not so much the most violent, extreme vilification of groups, but rather you write about the circulation of more moderate, less offensive speech. More mainstream speech can be more harmful, you write, because their audience is larger and the message more insidious and likely to have a larger societal impact. So, uh, how are we as a society supposed to address these kinds of harms that flow out of more seemingly benign, seemingly less offensive speech?
Yeah, I mean, one of my arguments is that when we think of hate speech law, we should think of its function as not as a practical matter, not to prevent the spread of bigoted, discriminatory views across society. That's just not a kind of a practical option. Law can't really achieve that. And so I think when we think about hate speech law, we should think about the most extreme forms of speech that can be shared often by small groups of individuals, feeding each other, emboldening them to take more and more radical action against the members of a particular group. Of course, as you say, I think that bigoted speech, stereotypes, which are just commonplace across society. For that very reason, law can't really address them. It certainly can't, expunge them from public conversation. So, yeah, I mean, traditionally, historically, I would have thought, okay, we need to think about ways. We need to think about the distribution of communicative power so individuals have the ability to respond to this. We need to think about the ways in which, and this is from another era, traditional media, address these things and didn't just give them a platform. So we need to think about all those things. And obviously education, the works. It's more of a problem, of course, uh, in the current era with the circulation of things through social media where there are no meaningful filters. And I don't know what the answer is because there's no way law can intervene to expunge all stereotypes, for example, about different groups and so forth. So I don't have an answer to that. I think we're in a really difficult situation.
I'm glad to hear you mention education. Might it not be more education is the answer? This was Louis Brandeis's answer in the famous Whitney versus California case. Concerned also about no opportunity to think, to respond, to have counter speech. He adds, he identifies education as an important prophylactic to dangerous speech. So isn't it a matter of educating the public, making them more literate about the messages that they're receiving over social media, something our children should be learning? Is that might not be the path forward?
Yeah, I wish I could be more optimistic about that. Of course, we want to care about education. We want to make use of education, help people to learn, to identify conspiracy theories, deep fakes, whatever it might be. But again, in the online world, first of all, individuals are often operating within these particular spheres and often have limited exposure to other perspectives. It's also the case that many people have been persuaded by interested, and dare I say it, most often very conservative right-wing, entities, to distrust traditional sources of information, to distrust experts or whatever it might be, to distrust the mainstream media, whatever it might be. And so even when one speaks about education, it will be, well, that's a particular propaganda that's being put forward here. And so that really worries me. I mean, if we were all part of some larger conversation and all were willing to take seriously the views or perspectives of others and could have a serious conversation, then maybe we could say, well, yes, education, thought, reflection, but we're not really operating in that kind of communicative world anymore, if we ever were, but certainly not even close at this point. And that's the thing I really struggle about. I mean, Jim read something at the beginning. I see the way in which individuals hold to a particular view as a matter of loyalty to the group. Sometimes it doesn't even matter what the view is. It is the thing that makes you a member of the group, and holding to it and asserting it and insisting upon it is what connects you with others who you want to be connected to. And the dismissal of the views and perspectives of those, on the other side of things, if that's the way to put it, is really, they are misled, they are misleading, they are, I don't know, vile, whatever it might be. And so education, yes, but I'm also pessimistic about its value in the current communicative environment.
I mean, you're describing the circumstances of the U.S. presidential election, and
Sure.
doesn't it suggest that our issues around freedom of expression are really driven by particular political contexts in which we live? And indeed, it might even be more technology that might provide some of the antidotes to deep fakes, to fake sources, fake
Yes.
news.
Except how those things get implemented becomes the subject of great political dispute. I mean, think about what's going on in the public schools and universities in the United States at the moment. That's become the ground of, I don't know, dispute, disagreement around a whole range of issues in which teachers are precluded from teaching certain things, certain perspectives. So education, if that becomes our focus, then itself becomes a different battleground that's highly polarized.
Indeed, indeed. So maybe it's time to go to questions. And Ange, can you tell us what the first question is?
Yeah, and I do first want to remind attendees you can use the Q&A button at the bottom of your screen to ask a question at any point. The first question is from Fred, and Fred says, there's a fine line between disinformation and heterodoxy. Can we trust legislators and regulators to maintain that distinction?
Yeah, I mean, I guess if I have an answer to that, the problem is that legislators have not, to this point, attempted to address disinformation in a large sense for obvious reasons, partly for the reason you're pointing out. As I say, in very, very limited ways have governments through law sought to restrict false, misleading, deceptive claims in the context of defamation, in the context of false advertising, and more recently around election campaigns and very specific sorts of false claims that might be made about a candidate's qualifications or about the circumstances or timing of an election or the location of voting. they have not tried in a larger way to restrict disinformation, not through law at least. And I think the reasons are obvious, because first of all, you know, we have to identify something as false. Do we know it's intentionally false? Sometimes somebody puts something out there knowing it to be false, but it will be picked up and circulated by others who believe it, take it seriously. And, the traditional protection of free speech has always been about, well, we have to confront false views. We have to debate them. But we have this fundamental problem at the root, and that is, how do we decide what's false? Who is the person to determine it? How we decide whether somebody is really lying or not? Of course, there are ways to do that, but through law, that's going to be a very difficult and messy thing. And we haven't gone there yet, even though, as I say, I think the spread of disinformation is, our biggest challenge to public discourse now. So thanks for the question.
Ange, next question.
Yeah, the next question is from Peter. Peter says, in your first book, you make the distinction between freedom of expression as a constitutional right versus a political claim. And the first book was about the former. Am I right that your new book does not stick so closely to that division? Can you explain how you see the legal right to free expression and what I might call public discourse ethics that do not directly involve the government per se, i.e. the subject of much of the controversies over free speech, cancel culture, discussion on social media that doesn't involve government regulation, but private companies' content moderation? Yeah.
Well, thanks for having read my first book. I'm grateful and paid attention to it. That's great. Thank you. Yeah, I mean, I think I was just trying to make the point that if we put our exclusive focus on the constitutional right, which causes us to focus on government action and government censorship, we miss an awful lot of what's really going on when we talk about free speech. And one thing David and I didn't talk about was the way in which we should care about, if we care about free speech, if we think it's valuable for individuals to express their views, to engage with others on various issues, then we should care about individuals' opportunities to express themselves. We should care about communicative power in some way. But the ability of the courts adjudicating under a constitutional right to engage in any kind of, redistribution of communicative power or opportunity is pretty limited. I mean, the courts are an appointed adjudicative body. They're not a democratic institution. They can look at the system overall and make adjustments to it to try to make more fair communicative opportunity. So the focus, if we look only at the constitutional right, we miss all kinds of important things about speech. Again, one of them being communicative opportunity or power. Do individuals have a meaningful opportunity to participate in public discourse? And we miss, obviously, a concern around private censorship. I mean, before the internet, there was a legitimate concern that newspapers, broadcasters, and so forth, were central platforms of a public conversation. They were, the public sphere, or central parts of the public sphere. And yet, here were the owners, the editors who could control what views were promoted, advanced in different ways. And of course, we have now the problem that social media platforms of different kinds are the principal channels of public, or principal platforms of public conversation. They are privately owned. And if we're just looking at the constitutional right to free speech, well, it would appear, and I know there's some trying to make an argument against this, but it would appear that they are not subject to the charter. They can, restrict or determine what stays up and what goes down. They may be bound by certain contractual obligations that they themselves establish, whatever it might be. Or they may be subject to laws that we enact that place some obligation on them to behave in a fair, even-handed fashion to ensure that individuals are not arbitrarily excluded from a platform or particular views are not excluded, although even that will raise certain constitutional issues. So yeah, I think that concern still remains. We need to think about free speech, yes, as a constitutional right, but not exclusively as that, and recognize that we should talk about freedom of expression and in a variety of contexts, even though there may be no constitutional recourse, no constitutional right for me to access, I don't know, the pages of the Globe and Mail or to post something on Twitter that may get, shut down.
If I can just add a few words to that, I do think that the courts exercise a distributive function. Firstly, you described in Dolphin Delivery, the court protecting economic interests, that free speech can be sacrificed in order to ensure that economic harm isn't suffered. So that has distributive effects. And also the courts have decided to whom the charter applies, and they've restricted the application of charter rights to a wide sphere of activities, like universities, for instance, that could otherwise have been the case. In fact, I was convinced by Justice Bertha Wilson's dissents in a sequence of these early cases where she made the case that the charter applied to entities that were like government, that performed government functions, like universities, like CBC, or any number of spaces in which freedom of expression in particular should be freely exercised, but there are no charter or constitutional rights available in those circumstances. So I think the courts, in fact, have played that distributive role and haven't been interested in redistributing so much as enclosing the space in which constitutional rights can be exercised.
Yeah, I mean, we have to remember that our democratic institutions through legislation can do something to ensure people have meaningful access to a variety of platforms and so forth. Our courts to this point have placed their focus primarily on state-owned property and have said that when it comes to state-owned property, you have, at least in the case of those properties that are ordinarily accessible by the public, you have a right to communicate on those properties, streets, parks, the legislative grounds, and so forth. But they struggle with how to define the scope of that, and certainly are unwilling to move beyond that and establish some rights in relation to private property owners, including the private owners of meaningful communicative resources like internet platforms or newspapers or whatever it might be.
I think it's an unresolved constitutional problem. And the more that one looks abroad and undertakes a sort of comparative inquiry into this question, one learns that it's not so much of a problem, actually, to have some constitutional rights applied to private actors, but Canadian courts have been extremely anxious about expanding the scope of constitutional freedoms in ways that seem unjustified in light of the record in other countries.
Yeah, we could probably go into this more, but yes, let's carry on.
It's a plea to do more comparative constitutional law, and for courts in particular and lawyers pleading before them to offer evidence of what goes on elsewhere. So, Ange, how about a next question?
Yeah, the next question, an attendee asks, they say, at some universities like York and Alberta and Calgary, the university presidents called in the police almost immediately after the protest encampments were set up on their campuses, as Jim Turk mentioned in the introduction. This meant the student and faculty rights to freedom of expression and assembly were squashed. It seems to render meaningless the Charter's assertion that these are fundamental freedoms for Canadians. In the two injunction cases I've read, the judges in the end ruled that the university's property rights trump the students' protest rights. Is it that simple? Is it proper to treat universities having absolute control of their outdoor quasi-public spaces as no different than my right to control what is done on my backyard? What does that mean for the reality of charter rights of student and faculty to protest what their universities do?
Yeah, well, I think David and I are sympathetic to the perspective of the questioner here. I mean, the first threshold question, and David was, of course, referring to this earlier, is whether or not the charter is in fact applicable to universities. And as you know, our courts early on said, well, universities aren't government actors. They operate in a substantially autonomous way in their governance, and academic freedom is important. And therefore, despite all of the connections with government, despite the function they perform, we are not going to treat them as government actors. But there was another line of cases that said, even if an entity is otherwise a private actor, when it is carrying out government policy, implementing a government program of some kind, its actions may be understood as government action subject to the charter. You can see the sense behind that if, for example, if our government were to privatize or farm out the incarceration of prisoners to private prisons, you hardly want to say, oh, suddenly prisons are not subject to the charter, et cetera. So, in fact, the Alberta Court of Appeal has said that in some of the functions it performs, universities may, in fact, be engaging in government action. And one of those functions is regulating speech on campus. The Ontario Court of Appeal to this point has not taken that view, but a couple of things have changed since the original decision. One of them was the Ontario government requiring all provinces to put in place a free speech policy specified in certain ways and subject to review by a particular body appointed by the government. Not that that body seemed to engage in any meaningful review anyway. And the other is the provinces said universities have to put in place hate speech, anti-discrimination policies in relation to speech on campus. And so there is a stronger and stronger argument that, in fact, when regulating speech on campus, universities in Ontario are, in fact, subject to the charter. Now, that doesn't answer all the questions. And let me add, I mean, the various universities involved will all have some kind of policy that expresses a commitment to free speech on campus. And so they're also bound in some way by their own policies, but that's not a constitutional argument. That's a different kind of administrative law argument. But in any event, and then the next question really is, well, what about these encampments? Are they a form of expression, and what counts as a justified limit? And I don't think there is any question, given how the courts in Canada have defined expression, that an encampment is a form of expression. It is intended to convey a message. And the challenge always is that any kind of protest, whether it takes the form of an encampment or an occupying a particular space or a march in a particular area, is always to some extent disruptive. It always, to some extent, interferes with the ordinary uses of a particular property or space. And so the difficult question always is, how much disruption is too much? Or for how long is it acceptable for this to occur before we say, it's too long, this disruption has gone on? I mean, as I said, I've said about the convoy protests in Parliament Hill. If all these people driving large vehicles arrived in Parliament Hill, honked their horns for an afternoon, made a lot of noise, blocked traffic, that would be one thing. But the fact that it went on for a long period of time seemed to involve significant disruption and harassment of people who either lived or worked in the center of Ottawa. That was too much. Now, that's a difficult judgment call about how much is too much. Certainly, to my mind at least, shutting these down, protests down immediately before they can even take hold or have just, been there for a day, that strikes me as an unjustified interference with the right to protest, with freedom of expression of those involved. And I believe that there is a constitutional challenge of some kind, certainly in Alberta, to the actions of the universities there, and particularly the University of Calgary, which really didn't let the encampment really even form at all. So I think there's a pretty good case to be made, certainly in Alberta in particular, that there was a breach of the right to freedom of expression and the right to freedom of association, freedom of assembly, excuse me, under the charter, and that it was not a justified restriction.
I'm going to put you on the spot, Dick.
Oh.
Justice Conan, not that you haven't been on the spot this whole time, but I want you to tell us what you thought about Justice Conan's annex to his decision in the Toronto encampment case. So as the questioner realizes, Conan concluded that the charter didn't apply to the University of Toronto, that it was treated as private property. So there was no a charter application. There was no charter analysis that needed to apply. But in an annex, in the alternative, so these were not officially part of his reasons, we would call them obiter, he does a charter analysis and finds it's reasonable to remove the protesters.
Yeah.
So what do you think about the reasons that he offered by way of an alternative charter analysis?
Yeah, I mean, first of all, I have been ambivalent initially on the question of whether universities were subject to the charter, but with the various actions the province has taken in relation to universities, as I say, requiring them to establish free speech policies, and then more recently, requiring them to put in place hate speech, anti-discrimination policies in relation to protests or speech on campus, I am persuaded now that at least when it comes to regulating speech on campus, universities should be viewed as government actors. This was dismissed very quickly and very easily, I guess, by this judge, and I think that's probably wrong. And certainly if the charter is applicable, and even if it's not, the idea of just saying that, well, it's their property, they get to do what they want. Certainly if this is, if they are subject to the charter, that is just not an acceptable answer. The real question, to my mind, should have been, this encampment, say at the University of Toronto, has gone on for a considerable period of time. They've made their point. They have disrupted, the use of this particular space for a considerable period of time. That's long enough. The university is entitled to say it needs to come to an end. One of the challenges for the university in the U of T encampment, at least, was that the way in which they fenced off this whole area with the object of keeping any kind of protest or demonstration out. And of course, that really meant the space was not available to people at all. And so it's hard to turn around and say, oh, this is space that people would ordinarily be using when they themselves fenced it off. And then, of course, it became the effective perimeter at least, of the protest itself and created a kind of protected space for the protest. But I do think that in the case of the Calgary protest, shutting it down before it could even take hold, that can't be justified as a legitimate or a reasonable restriction on free speech.
So the reasons that Conan offered in his charter analysis was that it were the same reasons that Justice Brown offered in the Batty case concerning the Occupy Toronto encampment at St. James Park in downtown Toronto, which was, it went on too long. And people want to use the park, want to use St. James Park. They want to, bring their kids, stroll their kids through the park.
Walk their dogs.
And walk their dogs was the thing that I highlighted in my own writing on this. And in Conan's circumstance, Conan's reasons, he was, offered, concern and consternation on the part of Jewish students and faculty, but he also said that people should be entitled to eat their lunch on King's College Circle, which actually had been under construction for 2 years and had only recently opened up, and then the fences went up in order to ensure that nobody would occupy the space. So that was pretty flawed strategic reasoning. In any event, he was alluding to similar sorts of what I find uncompelling argument in the face of constitutional rights and freedoms, right? You'd think that something more would be required other than dog walking, lunch eating, or it's just gone on too long. something seems to me that something more is required if we're talking about constitutional rights.
Yeah, I mean, if we are talking about a space that ordinarily would be used by others and they are actually physically displaced from it, then I can see there can or should be a limit to it. Exactly what that should be, reasonable people can disagree. I mean, my concern, and I probably share these with you, around the decision concerning the Occupy encampment at St. James Park was some of the reasons seem to be that people felt uncomfortable with the presence of the protest. Not that they were actually interfered with or couldn't use the space they might want to use, but they just felt uncomfortable with it. And he also put some weight on the fact that store owners in the vicinity felt the existence of the encampment was scaring away customers. Again, those just didn't seem like legitimate reasons to my mind to shut down a protest. There may have been legitimate reasons, but those didn't strike me as counting.
Right.
I should say to whoever posed the question, the Center for Free Expression blog has a number of posts on the question of encampments, several of which I wrote, if you are at all interested in a kind of more detailed account of the views expressed here.
Right. Okay, Ange, next question, if you could.
Yeah, okay. The next question, an attendee asks, is the kind of online harms legislation we see in Australia and the UK really an answer? Doesn't it turn Google, Meta, Elon Musk into the censors of our society?
Well, I will confess to not knowing the intricacies of what's happened in Britain and Australia. I know the British model has, we have drawn to some extent on that. I think, and this is certainly both a strength, but also there's some criticism of our current bill, is that it makes reference to the importance of taking free speech interests into account in making decisions about how these algorithms, how these systems are designed, but probably doesn't stress it enough. Because certainly a very legitimate concern with takedown rules established in different jurisdictions, most famously by Germany, were that the platforms would be overbroad in their application. They would play it safe if they thought they might be at risk, if they were to leave up something that counted hate speech or whatever it might be, and they would just adopt a very broad approach to what they regarded as hate speech and take a whole lot of stuff down, some of which might in fact not count as hate speech, might not be unlawful, and might in fact be appropriately protected. I think that the online harms bill is trying to avoid that, but it may be that it doesn't put enough stress on the other side of the equation, and that is ensuring the protection of free speech interests, while also being concerned about harmful, unlawful speech online and ensuring that it doesn't remain up. So I don't know enough about the intricacies of the British or Australian rules to comment on that, I'm afraid.
I don't either. Ange, could we go to the next question?
Yeah, the next question, someone asks, attempts to deal with what we call disinformation can be traced back to the statutes of Westminster in the 13th century and arguably have never worked. That aspect was removed from the British criminal law in the 19th century. Some aspects continue in common law, for example, defamation, fraud, but is there any way to deal with disinformation in criminal law?
Well, I mean, I think we've to some extent talked about this already. I think it's a real problem, and I don't have any simple, straightforward answers to this. You have the problem of identifying something as false, identifying the motive or knowledge of the speaker as knowing it's false, as lying, as being deceitful, and I think that's got to be a huge challenge. And I think that's why we don't really have meaningful rules. Even the online harms bill does not attempt to address disinformation. It addresses a variety of unlawful forms of speech, but it does not address disinformation.
And of course, the false news law was struck down in the Zundel case. So that
Yeah.
also was a relic of
Yeah.
older times. So there's not much left in terms of legal regulation. It seems to me if there's disinformation that causes physical harm, like
Yeah.
right, dangerous product that's not identified as dangerous,
But what about, what about vaccine,
well,
claims
that's
of
where I
different
was going to
kinds,
go. Yeah.
Yeah.
So vaccine disinformation borders that kind of concern about causing physical harm.
I mean, one answer has been for social media platforms to put up, when such claims are made online, to put alternative views and suggest this might be problematic and direct people to other sources of information. But certainly for those who are immersed in that particular world, there is no way, it seems, or it's very difficult. I don't want to say there's no way. I don't want to be that pessimistic to budge them from that kind of perspective.
Sure. Okay, Ange, next question.
Yeah, the next question, somebody asked, does the Quebec Charter not apply to private actors? What does that mean for expressive rights for those in Quebec?
Yeah, no, I mean, it does. And David, you probably know more about this than I do. I mean, it does establish certain rights, religious freedom and so forth, that can in fact apply to private actors. And so potentially its scope could be broader. But I don't know, David, you probably know more about this than I do.
I mean, there's not much more to say other than that the charter applies fully to Quebec law and to Quebec private relations, because those private relations are guided by the Quebec Civil Code in ways that private relations are infrequently regulated by statute in the rest of Canada. So the charter has much greater application in Quebec in the private sphere than it does in the rest of Canada, which is quite ironic because as I like to tell my students, the National Assembly voted unanimously against the Charter of Rights and Freedoms in 1982. And yet the charter has the greatest force in the province of Quebec. And again, that's also an opportunity, actually, examining that jurisdiction is an opportunity to think and reflect upon the expansion of the application of the charter to the private sphere, right? It's being done in Quebec. If courts are fearful of, as it seems to be the case, to have the charter applied to private action, look at what's going on in Quebec. There isn't a flood of litigation, which is the worry of courts, invoking the Quebec Charter of Human Rights and Freedoms at every opportunity. That's not happening there, and it's not happening in most places. So it seems to be an invitation really to rethink the Charter's application doctrine in the rest of Canada.
Yeah, I mean, we should add quickly that the vote against the Charter of Quebec legislature was very much a protest in relation to, the way in which the 1982 constitutional package had come about, in which Quebec
Absolutely.
did not feel a
Absolutely.
participant. But I was going to say too.
I don't want to be seen to be Quebec bashing. It was about patriation, and in fact, Quebecers like their rights. They like their rights. Canadians do. So I don't want to be seen to be.
Yeah, no, I knew you weren't doing that. But I was going to add to that, though. I mean, clearly, when you were talking about the civil code and how it regulates private relations and so forth, we're still talking about state action, and I know our courts have kind of struggled with how to understand common law rules and where to fit them within the charter, and they've kind of messed that up in many respects. But what's really interesting about the Quebec Charter is the way in which these rights, like freedom of religion, freedom of expression, apply to private entities. I mean, the case I'm very familiar with is a freedom of religion case, the Amslam case. It's effectively a condominium. That would be the language you would use in Ontario. And they were bound, to respect the religious freedom rights of the occupants of the condominium. And we're not, in Ontario, we're not going there. And it's sort of interesting to know how far that goes in Quebec and which private entities does it apply to and what restrictions, are there? And I don't know enough about that, the jurisprudence, to know.
Okay, Ange, next question.
Yeah, the next question, an attendee asks, how do we respond to claims of censorship when people use freedom of speech and expression as an excuse to spread disinformation on social media and have these kinds of posts or profiles taken down?
Yeah, I mean, I think probably we've said all we can say, have we not, around the question of disinformation. It's a real problem. And I don't know what role the state can play in regulating it without running a wide range of risks. As I say, to this point, they have focused on particular kinds of issues. For example, disinformation in the context of election campaign, misleading statements or false statements about the location of a poll, the timing of the election, the qualifications of a candidate, for example. It may be that we can and should be expanding the number of places in which, or contexts in which we seek to regulate disinformation. But excuse me, to try to regulate it in a very broad, general way, just as we've said, I think already, just raises so many challenges. And I just have not thought my way through yet about how a court, or at least how a legislature, might address this without all the risks that might go with it.
Ange, we might have time for one more.
Yep. Okay. So for the last question, what is your perspective on the recent rise of independent media, primarily emerging through online platforms such as podcasts, YouTube channels, and Substack? Do you believe this growing trend in digital media adequately addresses the challenges currently confronting legacy media in Canada?
Well, yeah. Obviously, I think it's valuable to have a whole range of perspectives and so forth. One hopes when thinking about legacy media and all the problems historically that went with their ability to filter out different perspectives, one hoped and imagined that they generally adhere to certain journalistic ethical standards. In other words, checking sources, correcting errors that may be that they may have published and so forth. One hopes that's the case, and I think that's probably true of most of the mainstream media. And I guess my concern would be some of these platforms either don't have the resources to engage in the kind of, I don't know, investigation, news reporting that mainstream media have, and some of them simply either cannot or are not interested in adhering to basic journalistic ethics. I know this has arisen recently in relation to rebel media, who I don't think anybody is really going to dispute. They don't really adhere to journalistic ethics. They don't really care whether something's true or not, as long as it advances the kind of particular perspective they would want to advance. So it's a good thing. At the same time, I have some concern about the adherence to traditional ethical standards of journalism.
Do we have time for one more, or we're nearing the end of our time here?
Time to bring Jim in.
Yeah, I think Jim will come back on.
Here I am. I want to thank the two of you for a really engaging discussion. All of us listeners got a class in law that was really helpful on a lot of difficult issues. And, both what you talked about and many of the questions put you both on the spot, and I thought you handled it very well. So thank you very much. And I want to thank the audience for your engagement with this. And I hope you share my appreciation and enthusiasm for the discussants today. This is also a launch for Richard Moon's new book.
I guess I should display it in some way.
So no, leave it there for a second.
All right.
Don't be shy about your old book. The Life and Death of Freedom of Expression. It's published by the University of Toronto Press. And I'd encourage you to read it. It really goes into many of these key questions that I think are fundamental for the future, our future as a democratic society. These are very serious questions that have to be addressed. So thank you for taking the time to write the book and your ideas tonight.
Yeah, well, can I say very quickly
Yes,
too? I
please.
don't know if this is part of that. Thank you for, giving me this opportunity, and thank you to David for engaging with this and, being, reasonably polite to me and all of this, so we can stay friends through all of this. But no, I'm really grateful. I'm grateful to everybody who listened in and paid any attention to this. So thank you.
Now, a video of tonight's discussion will be posted on the CFE website tomorrow. So if any of you have listened to it, found it really interesting, want to share it with your friends or contacts or those in your networks, you can just go to our website, which is CFE for Center for Free Expression, cfe.torontomu.ca. And by midday tomorrow, this will be posted. And along with it, we'll post a link to Dick's book, as well as some other readings that you might find useful on the questions that were discussed tonight. I also want to draw your attention to our next event, which will be a week from today, on Tuesday, October 1st at 7 p.m. Eastern Daylight Time. And it's about another thorny subject. It's what to do about foreign interference. As you know, Canada's Parliament very hastily adopted what's called Bill C-70, which was titled Countering Foreign Interference Act. And that bill raises serious civil liberties concerns in its plans for a foreign influence registry, new powers for CSIS, and significant changes to our criminal code and to the Security of Information Act. Our guest is going to be Nick Robinson, who is a senior legal advisor for the International Center for Not-for-Profit Law in the United States, and the author of a new report on foreign interference registry laws globally. So he's going to have an international perspective that he's going to bring in conversation with one of the leading Canadian experts on this, Tim McSorley, who's the national coordinator of the International Civil Liberties Monitoring Group. And they're going to be talking about how do we effectively address the serious issue of foreign interference while fundamentally protecting basic civil liberties in our country. So I'd encourage you to come next week. The details of this event, our past events and upcoming events are on our website, again, cfe.torontomu.ca. Thank you so much for coming tonight. Good night, everyone.